copyrights or trade secrets. We have a great panel, in keeping with the CPIP's tradition of short introductions. We'll be introducing them in order. We have Professor Stephen Haber from Stanford University, and then following him will be Brad Sheaf, Chief Intellectual Property Officer from Dominion Harbor. And then speaking third will be our very own Professor Sandra Astars, who is Professor of Law now here at George Mason University School of Law and a Senior Scholar and Director of Copyright Research and Policy at the Center for Protection of Intellectual Property. And then last but never least is Terry Hart, Director of Legal Policy of the Copyright Alliance. So without much further ado, Steve.
Okay. I'm not interesting enough sitting down, so I'm going to present from here, and I hope that this mic picks me up.
Yeah.
Okay. Oh, I got to get my PowerPoint up first, because I'm also not interesting enough without a PowerPoint. I'm a humble man of simple taste, as Adam will tell you. Okay, so I'd like to talk today, or at least you got the joke, about intellectual property and the wealth of nations. And this has been sort of a leitmotif of this conference, which is, well, but for the patent system, what would the world look like? And so on the top here, this is per capita GDP of every country in the world that has more than 10 million people in it. So we get rid of the small countries. And that does not include countries that have lots of oil and very few people, right? So Saudi Arabia is not there, or Norway's not there. And you'll notice that there's an interesting break, which is these are the countries that are one standard deviation above the mean in per capita GDP. Those are the countries that have $30,000 or more in per capita GDP. And you won't be surprised about who is in there. It's the United States, Sweden, UK, South Korea, etc. And then you'll notice that there's this sort of break point and a large number of other countries. I put China here for relief so you can see more or less where China is. We'll come back to this later. And Brazil here, which I'm going to talk about in some detail. And you notice they're a long way off from the high per capita GDP countries. And that's important because I'm going to show you later on how Brazil did from the period from 1750 to the present. One of the points I want to make is it's really hard. It's really easy to move from here to here, and extremely hard to move from here to here. And the reason that it's really hard has to do with the bottom frame here, which is the strength of property rights around the world. So you can see here the orange countries are the very high per capita GDP countries on top. Now if you look at the countries with strong private property rights in the bottom, you'll see they're lining up pretty closely. You don't need to run multivariate regression analysis to see these things are related, and that causality most likely is running from property rights to GDP and not the other way around. And again, you'll see Brazil and China here sort of lining up. And the question's why? Because the debate about intellectual property is part of a larger debate about property in general. Our focus here is intellectual property, but has come up in many of the presentations. Lots of other kinds of property have to work, and rule of law has to work as a system in order for there to actually be an effective IP system. Okay. So the question is, why do property rights matter for economic growth? And the answer goes back to Adam Smith. Maybe law professors ought to read Adam Smith. Economic growth comes from gains from trade, which permits specialization, and specialization encourages productivity growth. And so in a well-developed market economy, what you tend to have is you can understand the economy as a web of contracts. That is, you have large firms here in red, you have individuals here in green, you have small businesses in blue, and everybody is contracting with everybody else in order to capture gains from specialization. The person who taught me this was not an economist. It was my daughter when she was 9 years old. And she said, "Dad, I'd really like a horse." And I said, "Oh, horse? Yeah, no, you can't. I can't afford a horse." And she said, "You don't have to buy it. You can lease it. In fact, Dad, we can get a half lease." And she then started to explain to me the rental market for quarter horses. Yes, she got the horse because the kid was really smart. She later talked me into another horse and another horse. Yeah, no, but we won't go there. Thank God for consulting. So anyway, what you see in a well-developed market economy is this web of contracts. What permits that web of contracts? Well, it's a property right. Because without the property rights, you can't write there's nothing to contract around. One crucial component in this web of contracts, it's not the only one, are intellectual property rights. I want to be clear here that I agree 100% with my friend and colleague Adam Mosoff that a patent is not a grant of monopoly. A patent is a property right. It may be sold, transferred, or licensed. The important point of the property right system, or the patent system, is not its value from the point of view of the inventor. From the inventor's point of view, the patent allows he or she to appropriate the returns from his investment in developing a technology. That's important, but it's not the only thing that's going on, and I don't think it's necessarily the most important thing that's going on. The real thing that's the most important thing here is that from the point of view of society, the patent is a property right that can serve as the basis for the construction of a web of contracts, and that web can extend far beyond anything the inventor, that is the patent holder, initially imagined. So here's an example of how a property right allows a web of contracts to emerge. I can lease this car from Porsche because Porsche has a property right, a real property right, to that car, such that if I don't make the lease payments, they send a guy with a baseball bat and a tow truck. Well, it's Porsche, so they send a guy with a tie on a tow truck. Now, the important part of a property rights system, one of the other features is the ability to trade a contract. Okay? So Porsche can sell my lease to an investor because it can transfer its property right, and in fact, they do. The investor can in turn pledge the lease as collateral for a bank loan because U.S. law permits movable contracts or movable collateral to be traded. Not every country in the world, in fact, permits this. From the point of view of the construction of the car, the manufacturer, that is Porsche, can contract for parts from a supplier because the supplier has property rights to those parts. That is, he has a real property right. And the supplier can in turn take the contract from Porsche and obtain credit because he has the right to receive income from that contract and be collateral for a loan. That is, again, relying on the U.S. system, which allows you to treat a contract as collateral. The supplier can now pay the royalty owed to the inventor of the underlying technology. In this case, all the patent holders, many of them, who hold patents that read on or that are necessary for a direct fuel injection system, which is the frontier technology in fuel delivery in high-end cars. And that inventor can in turn contract with the supplier to use his technology because he has an intellectual property right to it, a patent. This is a very complicated way of saying that what this car is something that should be in my driveway but isn't. That was a joke. I don't like the Cayenne. But it's also the outcome of a web of contracts. It is no accident that this car was developed and produced in a country with a very well-developed system of intellectual property rights, real property rights, and property rights in financial contracts. If you doubt that, I encourage you to go buy a Soviet-made Lada and compare it and ask yourself whether or not the two institutional environments could have given you the same product. What's the government's role in all of this? Well, it's supposed to simply facilitate the operation of the network by specifying and enforcing the property rights that are the basis for the web of contracts, and it must do equally for everybody. Specifically, it delineates the property rights by specifying their boundaries. It makes those rights transparent by maintaining registries. It enforces those rights using its police power. And it makes those rights transferable by fairly adjudicating disputes over property rights and contracts. But the important part is this: equally for everyone. There has to be rule of law for this to work. And I need to talk faster. What's the outcome? Falling prices for consumers. This is the real prices, real quality adjusted prices of consumer electronics sold in the United States in 1997. This is from a paper of mine with Ross Levine and Alex Galetovic, just published in JCLE, where we look at the long-run prices of consumer electronic products full of SEPs, and the rates of price fall, quality-adjusted price falls, more than 10% a year, which by the standards of human history is the fastest anybody's ever recorded. All right, in a couple minutes I have left, I want to talk about what the web of property rights allows that's really quite rare in world history. So this is the United States divided up by metropolitan statistical areas. This is GDP by metropolitan statistical area. The red places, here out, their standard deviation out from the mean. Here's all the blue places. Now I want you to notice that even the blue places, way on the left is Flint, Michigan. Everybody makes jokes about Flint. By world standards, Flint's really quite well developed. It's got a per capita GDP of almost $29,000. The Brazilians wish they could be Flint, Michigan. These places here, I don't have a lot of time to spend on them. Who do you suppose is the richest metropolitan statistical area in the United States? Yes, it's Texas. It's Midland, Texas, followed by the Silicon Valley. Now, I want to make 2 points here. Both of these, and in fact, this one here, Milwaukee, which we're going to talk about in a minute, both of these and Milwaukee all have one thing in common. Okay, it's not beer, it's not dust, they're all based on IP. You could take Silicon Valley out of the United States and still have a really rich country. Think about Milwaukee. What drives the Milwaukee economy? Well, it's industries like, or firms like Johnson Controls, like GE Healthcare, and like Rockwell Automation. Those are the drivers of the Milwaukee economy. I don't have a lot of time, but all three of these big firms are all intensively based on IP. In fact, here's a Rockwell patent. What about Midland, Texas? Well, it's not like the oil and gas in the ground just crept under there yesterday. It's been there for eons. But the technology to get that gas out of the ground has been developed over the last 60 years. That is, the technology is fracking, but fracking is not a new technology. This goes back to something David Kapos talked about at lunch, which is fracking is the outcome of many incremental developments that go all the way back to the 1940s. And it was the combination, about 12 years ago, the combination of all these different patented technologies for horizontal drilling, slick water fracturing, and putting in propping agents that allowed fracking to take place. One of the other characteristics of the US economy, which you get from a web of contracts, is that even the largest patenter, this is just patent counts by year, okay, so this is the largest 300, even the largest patenter only accounted for a little over 2% of all patenting, and even Rockwell Automation is in that group, and so you actually have a large number of fairly small firms participating, and amongst those small firms, is Stanford University, with 170 patents taken out in 2013. Here's an example of a Stanford patent. I don't have a long time to go into it. Won't surprise you to know that Stanford has quite complicated and well thought out systems of sharing of royalties and taking equity positions in companies, including initially Google, which was developed at Stanford. And that Stanford's not the only university with a large patent portfolio in the United States. Why am I showing you this? Because it suggests that the web of contracts that drives a high-income economy allows lots of people and entities to participate, including professors who, otherwise would be working at 7-Eleven, are able to be part of this web of contracts. Why in the United States has there been so much focus on the patent system? So here's estimates of gross domestic product per capita going back to 1750 to 1913 for Brazil, France, the Netherlands, the UK, and the US. Who is at the bottom of the list in 1750? It's the United States, tied with Brazil. The United States at 1750 is an agrarian economy. I know we don't teach this when we learn American history in the 4th grade, but the only reason we won the Revolutionary War was because the French Navy helped us do it. Right? We were dead without France. In order to catch up with the UK, France, Netherlands, the great world powers at the time, the Founding Fathers were quite fixated on the idea of develop a modern economy or become a colony again. And so the patent system needs to be understood as a deliberate attempt at catch-up. I don't have a lot of time to go into this, but there's 2 big patent acts in the 19th century. First 18th and 19th century, the 1790 Act and the 1836 Act. Adam knows a lot more about both of these than I do. The point I simply want to make is this, is that both of those acts set off booms in numbers of patents, and they extend across a broad range of industries, including agriculture, transportation, construction, manufacturing, and include a broad range of people, including, interestingly, large numbers of quite common people, farmers and artisans, and including large numbers of women. They also include Abraham Lincoln. Okay, now to wrap up. So what happens when you move from a system of property rights that are uniformly enforced for everybody to a system where government bureaucrats are going to pick winners and losers and decide on their own, whatever criteria they have, who's going to have property rights and who isn't? Well, you're not going to get a network that looks like this. You're going to get a network that looks like this, in which there's one big firm, 2 big firms, and everybody has to contract with them because the government has decided only they have property rights. Now, the government doesn't necessarily have to just say, we're selectively doing this because we like these guys. There's any number of reasons, including intense lobbying by large firms with deep pockets against everybody else's right to intellectual property. You then wind up with a network like this, which has 2 big disadvantages. The first is, in this system, my daughter couldn't have gotten the horse. Horses, yeah. The second is that you get the Brazilian economy, which tried to create a Silicon Valley in the 1980s and has been trying to create one ever since. I don't have a lot of time to go into all the things Brazil did to create a Silicon Valley, but one of the things they didn't do was to create a system of property rights enforced equally for everybody, and property rights across a broad range, not just IP, but finance and real. So what was the outcome? Okay, if you went back to 1990, here's China, and here's Brazil and the distribution of world GDP, and you can see neither one is in the group of very high income countries. here we are again today. China's managed to converge towards Brazil, and Brazil's per capita income went up from $10,000 to $15,000, but in those 25 years, Brazil still didn't get into the small group of very high per capita income countries. This turns out to be extremely hard to do. So what do we conclude from this? Well, the first is intellectual property rights are not about creating a Silicon Valley, but about creating a level playing field for everybody so that we're not creating Palo Altos, we're creating lots of Milwaukees. The US economy is rich because it's full of Milwaukees. Second, the Milwaukees and Midlands come out of systems characterized by webs of contracts. And those webs of contracts develop when there are property rights to serve as their basis. IP is an important component of that system of property rights, but it's far from the only one. It's part of a package of property rights. And if you weaken any of those links, you wind up not as being in this group, but as being in this group. Recall, Brazil and the United States, if you go back to 1750, they're about in the same place. The United States was a backwater of the British Empire. Getting from here to here, and then to here, was not accidental. It was an outcome of a property rights system, and that's not something we should easily forget. Thank you.
Brad?
Thank you. One of the reasons I so enjoy coming to conferences is you oftentimes get to hear things you never thought you'd hear. For instance, the U.S. economy is rich because we're creating a series of Milwaukees. That's not a sentence I had ever thought to hear. And what I'm going to talk about today is not something that comes from many of the panelists here, certainly those on the panel with me. Their talks come as a result of rigorous academic study. Mine does not. No one has ever accused me of being a rigorous academic. But it's just from a series of observations. And one of them is that human beings are, by their very nature, incredibly innovative. Right? That's why we're all still here. A problem presents itself, we solve it. And I would submit that within the United States, we're a very innovative people, and we generate a huge number of very innovative businesses. Where we're not particularly innovative is in how to market and leverage that innovation to take full advantage of the IP rights system that Steve just so eloquently described. So we're great at innovation, but we suck at leveraging it. Right? So when my co-founders and I started Dominion Harbor, we did it because there was so much cynicism around the patent system that we just didn't believe in, not only within the firm where we previously worked, but just within the market in general. And while we actually believe in the patent system, and no one's going to accuse any of us of being geniuses, we found that just from listening to clients, from huge international companies to just startups struggling to survive, that there's truly an opportunity for innovation within the IP marketplace. And that's why this conference is so timely. Now, it's fairly ironic that I carry the title of Chief Intellectual Property Officer at DHG. I'm not a lawyer. I'm not a businessman by practice. Well, I guess I am by practice. I'm certainly not by training. My background is I spent almost 25 years in military special operations and then as a special agent in the FBI. And so when people ask me, to describe myself, I guess I refer to myself as a patent law hobbyist, which there are not very many of, but I guess that's what I am. So again, my comments are based on almost 10 years of just frustrating experience after frustrating experience with patent markets and with those that are being harmed in those patent markets because people don't truly understand them, because we really do believe in the patent system and believe that it is a core component of our economy. So one of the things that, to me, again, I'm not formally trained in this area, but I just find remarkable about the Constitution is that the Founding Fathers recognized right out of the gate that we had to protect both stuff, right? You couldn't just take people's stuff, that wasn't allowed, and we had to protect their ideas. Right? You couldn't just take people's ideas. That wasn't allowed either. And we had that on the books from 8 o'clock day one. And I can tell you that having spent 25 years in the military and in the Bureau, we're great at protecting stuff. You take somebody's stuff, we're going to come get you. Doesn't matter where you are. Right? And we're going to take our stuff right on back. Okay? We are good at protecting stuff. We're not so great at protecting ideas, but that's not the fault of the system that was put in place to protect those ideas. We just don't practice it very well. So how does the current IP market work? Again, in my observations, it's kind of a bifurcated system. So I'm going to subdivide it into the commercial and into the legal. So generally, the commercial system develops the IP. Right? These are the entrepreneurs and the businesses. They're out there developing new innovations. And it's the legal system that initially protects it and then helps develop it and then eventually works to monetize it. And now they work in conjunction with each other, right? And it's at these points of intersection where you have the greatest opportunity of success. And again, I find in my experience, oftentimes the greatest examples of failures. So the concept that the commercial system is generating the IP and that the legal system is protecting it, helping to develop it and monetize it is fine, because entrepreneurs instinctively understand that they have to be innovative, right? I mean, that's, you know, if you're not doing something new within your market, you're not going to be successful. And they instinctively understand that somehow they have to protect that, because if they come up with a great innovation, it won't be very long before someone else does as well. And so it needs to be protected. Right? And the patent practitioners know how to make that protection happen. Right? I mean, that is the job of many in this room. Right? And by the way, I refuse to take any more criticism, having worked in patents for almost 10 years, about military and law enforcement acronyms. Is there any more Byzantine or nuanced language than that of patent law? I mean, I'm sitting in a meeting, I just get started with the firm I was previously at in a meeting, and someone says, hey, Brad, do you think that we should traverse the obviousness rejections under KSR or further amend the claims with additional limitations and thereby potentially read them off the accused instrumentalities? What? Okay. The former. Who doesn't love a good traversal, right? And let's traverse. Let's move from side to side. I still don't know what that means. So it's at these, and that's just a demonstration where it's these intersections of the commercial world and the legal world where you have opportunity, but you also, I think, at this point have a lot of failure in the patent market. So let's look at those intersections. Right? So intersection one is the initial protection, right? Where an entrepreneur has developed something, there's some innovative idea, there's some innovative practice, there's some innovative technology, this entrepreneur has developed, and they want to protect it. So they open up the yellow pages and find their friendly neighborhood patent attorney, right? And so they excel at the innovation part, the protection part they really don't get, right? So these are real examples from conversations I've had with clients or potential clients. Hey, we'd love to, have Dominion Harbor come on board, help us with our intellectual property. Great. Do you have any patents? Absolutely. Okay, great. Well, why don't you give me one of the patent numbers? I'll, sort of pull up your portfolio here real quick. Sure. 61/12, blah, blah, blah. Okay, right off the bat, right? Well, take time out. That's a provisional application. Right? So that's, not only is that not a patent, that's not even really an application for a patent. Well, what do you mean? Right, so now I got to explain this, right? Or I get the response of, oh yeah, we're just waiting for our patents. Well, what does that mean? Well, we filed the application, so we're just waiting, and we'll, eventually, if we go to the mailbox enough time, our patents will be in there. Right? So after having conversations like this with entrepreneurs who, again, are great at what they do, I ask them, well, who's prosecuting your applications? And that's sort of a loaded question. And it follows on from already having an expectation they really don't know much about their relationship with their intellectual property experts, right? So the response they usually get will be, huh? I mean, no one's being prosecuted in our business. Time out. Do you have a patent attorney? Oh yeah, we've got a really great firm. Really? Do you have a really great firm because you think your provisional applications are patents, or you think they're just going to come in the mail, and you didn't know that they were prosecuting them? So I question whether or not this relationship is a particularly good one, right? Now, I get it, right? I mean, inventors, I deal with inventors all the time. Everybody hears what they want to hear, and you have to be an incredibly gifted orator to not sound like Charlie Brown's parents when you're explaining patent law, right? So I get that oftentimes the patent practitioner is trying to explain it as well as he or she can, and the inventor only hears what they want to hear. But right off the bat, you know, this first intersection is not exactly off to a roaring start from the perspective of either the patent practitioner is trying to do his best by his client, or from the entrepreneur who has this instinctive knowledge that he's on to something good and needs to protect it. So the next intersection we have is after the initial protection, then there's the development of the portfolio, right? And so the entrepreneur acquires a little bit of vocabulary, can say things like portfolio, can say things like application, occasionally can say things like claim, right? These are all important steps for the entrepreneur. And to be honest, I really don't know what goes on at this particular intersection because we're usually not brought in until the third intersection, which is monetization, and I'll get to that in a minute. But I can tell you that I would love to know what goes on in this intersection because it's clearly a wondrous and magical place where reality is warped and no communication exists unless it's miscommunication. Right? But people feel really good about being there. Right? So I suspect it's down a rabbit hole or through a looking glass or someplace like that. And the reason I say that is because it's at this intersection where somehow two well-intentioned groups, the commercial group and the legal group, managed to take valuable innovation and reward it with not so valuable patent claims, or take no innovation at all and reward that with completely valueless patent claims. Right? And then somehow there are applications filed and prosecuted, and subsequently patents are allowed, are issued, registered, nationalized in Belize, in Luxembourg, in Monaco. I mean, these are all real examples from clients we've had where I'm reviewing their portfolio. You have a patent in Monaco. Yeah, it's great, isn't it? I guess. Anybody doing this in Monaco? All right. So during the development of the portfolio, what happens? Right? And then the last intersection is the monetization of the portfolio. And I'm frequently in this sort of melancholy position where I have to be the bad guy explaining to the client that whether they're business executives, they're entrepreneurs, or established business leaders, that their patents don't really protect what they thought they protected. And in many cases, they don't protect much at all. Right now, again, most of us in here have worlds of experience with inventors, so they all think they invented oxygen or fire. And then you have to explain to them, well, no, you can only really lay claim to things that are within this disclosure here. And actually, the only inventions you have are the metes and bounds of which are the claims. Right? And somehow they get all the way to this point when they've come to a group like Dominion Harbor, who they're looking to help optimize and derive some value from their patents, for someone to tell them, hey, there's just not a lot of value inherent in what you've done. The idea was great, your products may be great, but your intellectual property just hasn't kept pace. And so the patent system was conceived and designed to support innovators and commercializers with valuable, neatly packaged property rights to innovations in a transferable, marketable fashion. I mean, that was why the patent system was conceived and designed. Right? But this current bifurcation between the commercial sector and the legal sector is not helpful for either, right? Whether we're talking about commercializers or innovators. And it's created a niche of contractors or specialists who focus exclusively on licensing, and that's to the detriment of both innovators and commercializers alike, and has harmed IP rights overall. So to a certain extent, you get that when the legal system drives the market, right? If the legal system drives the monetization market, you tend to get legal answers to those questions, which would be, well, we'll license these things, right? When the commercial system drives the market, then you get patent cost centers, where R&D is theoretically captured in patents, and then nothing happens. Right? And so What then happens in large organizations, we have a number of Fortune 50 companies that are clients, we always get contacted by the general counsel's office, right, who said, well, I got these things, theoretically I'm responsible for this, these patents, I got to do something with them, can we sell them, can we license them? And so what's the solution? I think the solution, much like the topic of this panel, is to find some innovation in market making, right? Better cooperation and mutual education to bridge the gap between those two systems. So in intersection 1, right, for the initial protection intersection, we need market makers that can speak and understand both entrepreneurship and business as well as the law. Right? Christina's telling me I have very little time. I have a wife and 4 daughters. I don't need one more woman giving me instructions. But I appreciate it. 1 minute. That's great. Yeah. All right. So the initial exchange between those that are generating on the IP and those that are protecting the IP needs to be one in which education is a foundation there. And again, I've noticed patent attorneys are pretty good at understanding what the entrepreneur is trying to do, but not as good at explaining what the patent practitioner, is trying to do, right? In terms of what they're actually going to be able to protect and what they're trying to protect. And then in intersection 2, with the development of patents, need to ensure that patents do protect those key innovations with real business impact that are well drafted and legally sufficient. Right? I mean, that is the objective. And I know that no one wants to hear bad news, right? And that your job as a patent attorney is to get patents, right? But it's in this intersection where bad news can oftentimes be the most helpful thing that you can do as a patent practitioner, is to sit down with your client and say, hey, look, this just isn't patentable. Or it may be patentable, but like a coffee mug with a thumb, no one needs it. Okay? So you may be better served doing something different. You may be better served with this being a trade secret. You may be better served moving in a different direction. Understand that other people have been here before you, and we may be able to tweak these claims such that you get them. But again, the coffee mug with a thumb, nobody needs it. And then lastly, that gets you to a much broader range of options when you get to intersection 3 for monetization. Licensing is not just the only option. It's viable. We believe at Dominion Harbor it will remain viable, but only in the right circumstances. Only when you can make a business case, as the gentleman from Ford talked about. It was great. I wish there were more executives like that who will actually listen when someone says, hey, look, I think we've got an opportunity to do a licensing engagement here. But you can also invest those patents. One of the things we do is we'll take patents from our larger clients who are just paying maintenance fees on patents that are collecting dust, and we will invest them in some of our smaller clients and automatically give a boost to their IP portfolio in a way that is near real time and doesn't take the 36 to 48 months to generate your own IP. And then we'll help them develop their own core IP. So we've solved 2 problems. We've got patents off the books of guys that are trying to get them off the books, and we've got patents in the hands of those that really need them to help develop their market space and drive down their cost of capital. And we don't charge anybody for that. These guys are making an investment, we're making an investment, and that's the way that process works. Or you can sell them, or you can donate them, and we'll tell you if your patents suck, honest, right? And then you can abandon those, right? So the secret is to educate both parties in what each party is trying to do, and then make a business case. And when you tie those 2 things together, when the entrepreneurs and the patent practitioners each understand what each other is trying to do and work closely together, and you make a business case in the monetization intersection, then I think you can see some real innovation in IP markets, and that will be a better solution than the current morass that we're in with legislation and the judiciary all based around bad licensing. Thank you.
Professor Stars.
Yeah, so the panel topic is innovation in IP markets, and so you'll be surprised, I think, that I'm actually going to talk about something that Justin Hughes already told you is 20 years old and not the latest and greatest thing. But I'm doing this for a very specific reason. Morgan Reed this morning on the first panel told us that small companies and startups begin their existence broke and scared. And I told him after that panel that, in fact, big companies are really no different when they're starting a new project. They are just a collection of small companies within that corporation. And so they want the same things. They want stability, they want certainty, they want to focus on inventing and innovating in the areas where they're really excellent, where they've specialized, and they're hyper aware of their balance sheets. So I'm going to focus on technical protection measures, and whether you like them or don't like them, I think the contractual background and the IP underpinnings of these systems and how they've developed are interesting to look at because they're based on this web of contracts that we've been talking about, and they show that the web of contracts can sort of lead you to any conclusion. The strong IP protection that we have through the patent system, backed by the appropriate legal regimes to enforce it, including things like the DMCA and Section 1201, actually, in some circumstances, encourage businesses to make their IP available on terms that are more favorable, sometimes even free, and that allow a variety of industries to really build on those patent protections and developments. So the TPM marketplace is a very good example of this. And I chose it for a couple of reasons. First, consistent with the theme of the conference overall, the efforts illustrate how multiple types of IP protection work together to bring invention and inspiration across a variety of industries. But second, they really depend on the strong underlying IP protections and the legal regimes, but rather than using their IP rights and the associated legal regimes to maximize licensing revenues, the people who are developing these measures are making very conscious and very deliberate decisions to make their IP available to any interested company at rates that don't allow them to recover their R&D. Because what they see as a benefit is that this will spur the adoption of new formats more quickly for distributing works, and it will encourage people to release copyrighted works into those formats. And this isn't altruistic behavior in any way. It's smart business thinking. They are facilitating easy launch of new formats and services without imposing undue costs on those formats and services, and they're allowing everybody in the marketplace to focus on doing what they do best. So I'll distinguish this a little bit from what the panel this morning talked about. I want to be clear that although the collaborations that I'm referring to do entail years and years of engineering time, of lawyer time, of business time, but they're commercial licensing arrangements. They exist in the free marketplace, and the participants in that free marketplace, as I've already told you, are motivated by completely different things than folks who are looking to maximize their licensing revenue over a portfolio of patents. The efforts have been possible because people understand the trade-offs here. I'll give you a little bit of background and a little bit of understanding of the philosophy underlying the efforts. Over about the past 2 decades that the anti-circumvention provisions have existed, a variety of these efforts have sprung up, and they've successfully challenged or tackled the challenges that exist to the launch of various new consumer products. And they've allowed, through collaboration between CE companies, IT companies, and entertainment companies, they have developed these mechanisms and licensing regimes that impose rules on how the mechanisms will be used by the various participants that have made it easy and inexpensive to incorporate these systems into various platforms. They brought us DVD, they brought us Blu-ray, they've allowed for launch of a variety of home networking solutions, they've allowed for various storage and rights management systems to pop up, and they've all relied on a few very common principles. The use of the technology is always voluntary. There's no legislative or regulatory obligation to use it. The technology underlying these systems is all patented. In some cases, it also has copyright or trade secret protections associated with it, but it's largely patented. Rules are established through the use of license agreements on how the technology will be used. And those rules provide not just the security for the entertainment companies that are releasing content into these new formats, but they provide security for consumers and for the consumer electronics companies and IT companies that are participating in these efforts, that there will be at least a basic floor, a baseline set that corresponds with consumer expectations on how they can use content and share it among devices. And costs to implementers are ultimately kept low through the use of reasonable non-discriminatory licensing terms. Those terms are really aimed at just maintaining the operation of the licensing system rather than obtaining a recovery on R&D costs that have invested. And so why do people do this? Why do they seem so benevolent? They're not really benevolent at all. I mean, people are pretty realistic in these exercises. They realize that consumers don't like TPMs. It's not a value add for a consumer to have a technical protection measure built into your electronics device, into your distribution platform. And so they're not going to pay for it, and yet we need to incorporate these sorts of security measures to establish the baseline for entertainment companies to release their works and others to innovate and develop new services and products. So the TPM that we're talking about is merely an enabling technology. It's not what anybody in these efforts is really interested in focusing on, and they go and build on the enabling features of the TPM to go on and develop new products, new services, invest their money in bringing us great motion pictures, great sound recordings, and so forth. These licenses, just like Tesla's offer to cross-license its patent portfolio to anybody, they seek to ensure a level playing field amongst all of the adopters and to minimize IP risks. And so they are really cross-licenses in reality. They all include narrow non-assertion clauses for necessary claims. And actually, in practice, though, a little contrary to what I expect the result will be with Tesla, it's worked out to be more of a security blanket than an actual license, because in the 20 years that these sorts of efforts have been operating, I'm not aware of any necessary claims having been brought or suggested against the licensors of the technology, either within or without the web of adopters. But it's a valuable provision to include nonetheless, as anyone who does patent licensing understands, because it eliminates the risk of IP litigation amongst the licensees. It allows people to kind of scope out what their licensing costs are going to be and avoid unanticipated increases in those costs. And importantly, it preserves the incentive for those companies who have developed the technology and are putting it out in the marketplace at cost or below cost to keep doing these sorts of innovation efforts, because it would clearly be unfair that if you're putting your technology out to enable the entire marketplace, someone who adopts that technology on these low-cost terms could then turn around and assert claims at a commercial level against you. It also leads to stability in the spec. You're not constantly trying to adjust or update the spec in order to avoid claims and to respond to changes in the marketplace. The one thing that's interesting to me, and the area where the Section 1201 provisions have really been helpful, is that they've allowed these systems to hold up well over time. They've been hacked numerous times, but through the protections of Section 1201, and through this licensing structure that underlies the use of the technology, those hacks have been ones that have not really had a devastating impact on any of the formats that have adopted the technologies. They're still, valuable, lucrative formats, and the hacks have been cabined off more to the less commercial marketplace. But we're now in the process of reviewing the Copyright Act and updating it, and there are a variety of new online services popping up, any second, I presume. So there's a couple of things I think that the discussion this afternoon should help us keep in mind as we look at the Copyright Act, as we look at patent laws, and that's that although these sorts of regimes that I'm talking about rely on making their IP available at a low cost to enable these markets, they do that only because the inventors of the technologies have strong IP protections, and that our system of laws, including the Section 1201 provisions, allow us to impose rules that promote fair and balanced use of these systems, and allow us also to ensure that we don't need to constantly battle hacks and update the systems that we've developed. So as we go forward and look at Section 1201, which I believe the Copyright Office is suggesting we will do, I think we need to reflect on the value that it truly provides to the developers of technologies that enable entire marketplaces, both in the content system, content creation marketplace, in the patent protected world of consumer electronics and IT companies. And I hope that will be an issue that's not lost on the Copyright Office and on Congress as we move forward.
Well, thank you, Adam, and thank you to the rest of the CPIP team for putting on an awesome conference. We're here, the last panelist of the last panel. And I wanted to start off with a quote that echoes something that we've been hearing throughout this conference. This quote is from Batman, who said, in our well-ordered society, protection of private property is essential. I included this specific quote for a couple reasons. One, because I will be talking about some of the benefits that private property in the form of copyright specifically provides to society. But secondly, because this was quoted recently by the Ninth Circuit, in this case DC Comics v. Towle, where the Ninth Circuit held that the Batmobile is protectable under copyright law as a character. And this idea of protecting elements within works along with the broader derivative works right provides the legal framework of what I'm going to be talking about. And what am I going to be talking about? A remix. This is a word we hear often in the media and entertainment fields. It can mean a lot of different things, but for our purposes, I'm defining remix here as it relates to copyright. And remix, I'm saying, is a work that incorporates existing material that is in protected works, such that its use would otherwise be infringing if you didn't have fair use defense or you didn't have permission. So I'm going to be talking quickly about this idea of the remix critique, and then looking at the landscape, a universe of authorized remixes in the media and entertainment fields, and finally looking at some of the benefits that arise from protecting these elements and existing works under copyright. So the remix critique is something that has emerged in the last 10 or 15 years from copyright skeptics who were spurred by what they perceived as an expansion of copyright law. And one of the ideas that emerged was that instead of incentivizing creativity, copyright actually acts as a barrier to creativity. The idea is that all of culture, whether it's a book, a film, any type of story or image, can be reduced to a remix of existing culture. And especially with modern creativity, it's particularly reliant on explicit remixing of audio materials, of visual materials. And thus copyright impedes culture and creativity because it excludes people from using these existing works to create new works without permission. And given that copyright is supposedly expanding over time, this problem is only getting worse. I think this claim is vastly overstated. And in fact, even worse, it ignores as I said, this entire universe of authorized remixes that are both popular with audiences, are economically significant, and culturally relevant. So what are these authorized remixes that I'm talking about? Well, the most simplest form is retelling. The retelling of work from one medium to another medium, within the same medium, or any other type of retelling. So for example, you have adaptations. I have up here the Disney film The Lion King was adapted into a Broadway musical. You also have remakes. These are works that are within the same medium, and these have gone on for thousands of years. The Romans were remaking Greek plays to update them for their modern audiences, and we see remakes all the time. For example, the British show The Office was remade to the American version of The Office, and everyone has a different opinion on which one was better. More recently, we had this idea of reboots. This comes when you have a serial type of story, for example, in comic books or in a franchise, where over time, this enormous backstory accumulates, and soon it gets more and more difficult for new audiences to get into the story because they don't know all this backstory. So every once in a while, someone will have the idea, we're going to start over from scratch, reboot the series, and so that new audiences could come in and don't have to know any of the backstory that existed before. And then we move on to remixes that are new works that incorporate elements from existing works. So most popular example are sequels. You know, you have, as someone mentioned, Fast and Furious 1, Fast and Furious 2. But I think they didn't follow the same convention as that. It was Too Fast, Too Furious. And, you have spin-offs. This is especially popular in television, where you have secondary characters like Frasier, who was in Cheers, and then they spun it off into his own series where he was the main character. Film sequels today are very popular. I have a figure here. They're nearly $2 billion annually in box office revenue today, and that's doubled from the 90s. And then we have more complex types of remixes here, including mashups. If anyone's seen the Lego Movie, there was a wealth of characters portrayed in that film. And they were all licensed, the ones that were still protected under either copyright or trademark. So you had characters from Harry Potter and Star Wars and the like. And more today, we are seeing a lot of follow-on creativity that simply uses existing works as raw material to make new works, but a lot of it is happening in an authorized legal way. So you have, of course, stock footage and stock photography. The Harry Fox agency has administered a license agreement with YouTube and the music publishers at sharing the royalties that are received when users upload their own user-generated music videos incorporating protected music. And a year or so ago, actually a couple of years ago, Amazon introduced this initiative called Kindle Worlds, where they took 30 properties, some very popular like G.I. Joe and Veronica Mars, and they opened it up to self-published authors to be able to write their own works using these characters, using these settings, and actually make them commercially available. And so far, over 600 titles have been produced. And finally, creators of all types always have the option of putting their own works out there as raw material for remixing under public licenses like Creative Commons, which explicitly authorizes any type of follow-on creativity. So what are the benefits that come from this? Well, the benefits from the owners of the properties are pretty obvious. These existing works give them a built-in audience. Any work in any of the media and entertainment fields is inherently very risky. A lot of works don't recoup the costs that go into them. So you're able to reduce that risk if you use something recognizable. They have a built-in audience. This explains seemingly bizarre sequels like Jarhead 2, which went straight to video, but which was successful, at least financially. Disney's been very successful using direct-to-video with its properties. And of course, some copyrighted stories and characters become these enormous, powerful franchises, Star Wars and Star Trek and the Marvel Universe, that generate significant new stories over and over again and significant revenues and significantly popular works. This, of course, allows creators to maximize the work's value. They're able to draw value not just from the original stories, but also from all the spin-offs or all the tie-ins or all the sequels. Lion King, Beauty and the Beast, Frozen, these are all examples of franchises that Disney has leveraged for decades now. In a recent article, Daniel Kelly wrote called The Right to Include. He points out that, we often talk about these exclusion mechanisms and the right to exclude. But what's often overlooked is that this actually enables and encourages inclusion in property. The reason being is that if you have legal mechanisms to protect your work, you're more likely to enter into the web of contracts that was discussed earlier, because you're protected at least if someone tries to take advantage of you. And he identified a number of specific benefits that flow from this. It includes the right to share, and this is a gratuitous transfer where copyright owners will invite fans or audiences to use their content. And this could be great from a marketing standpoint, or just building goodwill with fans and maintaining that audience for future works. It includes the right to exchange, which is your typical contractual arrangement. An example here is, in 1986, a lot of rap and hip hop was based on samples. Well, Run DMC wanted to build a song around Aerosmith's Walk This Way, but instead of sampling it, they actually went to Run DMC and they agreed to perform on their new work, and the new work became very successful and launched a whole genre of rock and roll infused hip hop. Financing is a big benefit in the copyright industries from being able to include others here. For example, in 2005, Marvel was able to use its characters as assets, as collateral, in order to secure over $500 million to start producing its own films. It wouldn't have been able to do this. It had just emerged from bankruptcy. But the characters were valuable enough that they were able to obtain financing off of that, secured by their characters. And finally, it allows people to spread the risk. As I said, these industries are very risk-heavy, so if you're able to include others, you're able to spread the risk. If you're going to be able to not only make a movie, but make the novelization of the movie, make the video game based on the movie, you're spreading the risk out because there are more avenues to be able to bring in revenue. And then, of course, specialization, which is key to any market economy. Inclusion allows everyone to focus on what they do best. Creativity, especially, is largely serendipitous, so that, if you're able to have multiple people working on multiple products, you're going to end up with better products overall. Finally, for audiences, there are benefits from this. They're very passionate fans for a lot of these franchises, for a lot of these characters, for a lot of these works. And allowing a copyright owner to retain control over those works, and including others, allows them to shepherd the works and make sure that the sort of inherent dignity, the benefits that the audiences enjoy about these characters aren't eroded by or diluted. So there's a funny example. After the first Star Wars movie was released, Lucasfilm wasn't really keen on policing their licensing too much. So they licensed out the right to make a tie-in novel to Star Wars. And the novel had a subplot that featured a romantic relationship between Luke Skywalker and Princess Leia. Well, the next film comes out, and it's revealed that they're actually related, brother and sister. So you end up with this really kind of confusing type of a world here, where you have books that are a little contradictory from the films, hopefully contradictory.
In the future, it's all going to be okay.
Right. Yeah. But nowadays, they don't do that. Lucasfilm is very on top of their licensing. They employ staff just to police continuity in all their different products. And the result is you have this franchise that remains successful over decades, remains financially successful, remains popular among multiple generations who really appreciate the fact that there's this canon, that there's this continuity among all of this big world. And so I will end there. Thank you very much.
Thank you. Well, this has been a really great panel, and I'm going to take moderator's prerogative and just pose a question to the panelists, because what we've been hearing, of course, from everyone is, oh, awesome web of contracts, all these agreements that people are reaching, these corporate deals that they're entering into. But what a lot of other people hear when those terms are used is what they hear is cartels being formed. They hear backroom deals being reached that to raise prices or to suppress competition. And this ties into a little bit of the issues about antitrust and the use of antitrust that Dave Kapos was talking about in his keynote. So would any of the panelists care to address that issue? I see Steve's already going, yes. Care to address that issue or respond to that kind of initial criticism that you often hear in response to people who advocate for the private ordering effects of private property rights in intellectual assets, that this is actually a bad thing, not a good thing?
So I have bad news for those people. The world's not perfect. And any system that you want to posit has to be compared to another viable system. So the critique that there are imperfections, let's say, in any system of private contracting, it might get you, for example, cartelization in some cases. Yeah, it might. It might also get you a competitive market. And so you don't want to start with the assumption, as many of the critics or skeptics of intellectual property do, which is that the market-based system is inevitably going to get you to a place of oligopolistic competition. And in fact, that tends to not be what we observe in most modern economies. What we tend to observe are highly competitive industries in which firms rise and disappear. The phone industry, which came up earlier, is a classic example. Who's the dominant player in the United States? It's Apple. How long has Apple been in the phone industry? Since 2008? Well, what happened to the guys before Apple? I don't know. How many here own a Nokia phone? I rest my case. So the notion that these private ordering arrangements are going to get you pernicious outcomes, as an empirical matter, I don't think holds true, but it also posits a nirvana that would exist if only the government intervened more aggressively via antitrust or other levers, policy levers that government has. And the implicit notion that those critics tend to have is, of course, those government officials are going to be robots programmed to maximize social welfare. That is, they're going to be like tenured law professors at top 10 law schools. When in fact, what they're going to really be is just normal people who are susceptible to pressure, lobbying, and the screaming voices of their bosses about the outcome that their boss wants. I'll say no more about it than that, but it's pretty clear from the evidence around the world that when you replace a system of private contracting with government intervention, what you typically get are politically driven economies in which you get Brazil. Let's just leave it at that. You're going to get Brazil. And so there's this sort of kind of notion that, oh, there's all these sort of pernicious, and then there people will point to, oh, look, there's this bad case, there's Rambus. And I'll just say this, that there's what I call the Keanu Reeves problem. There are always bad actors.
Ouch. Any of the other panelists want to weigh in?
Yeah, I'll just make a quick comment. I think the technical protection measure example that I mentioned is actually the proof in the pudding, or whatever the correct expression there is, that private ordering results in benefits both for the businesses, for the consumers, and brings us new innovative products, because through these agreements that have been reached over years, you've kind of cleared space for innovation, and you've also enabled people to focus on the things that they really are good at and care to devote their innovative efforts to. And by keeping the costs of these sorts of offerings low, you're not passing additional costs on to the consumer. So the antitrust issues are certainly very important in how you structure the agreements and ensure that the people who are inventing the technology, which are a number of large firms, aren't collaborating on business plans or something like that in advance. But I think that the antitrust concern in this space has been not very significant.
It's interesting to me, Adam, that this same concept gets raised in all different types of contexts, right? So it depends entirely on whose ox is being gored and on people hearing what they want to hear. So when I was an agent, if I happened to be serving a search warrant on your house, then I was a jackbooted thug, a goon, a moron, outside of my rights, didn't know what I was doing, and getting a finger poked in my chest the entire time. The next week, when your house's door got kicked in a home invasion robbery, I was lazy and ineffective and not where I needed to be on time, and why wasn't I there? Right, so it just depends on who feels like their rights are being intruded upon at any one given time, and that same thing applies in intellectual property, in the intellectual property context. I mean, if it's your intellectual property that's being stolen, Google, then you're angry about that. If someone's accusing you of stealing their intellectual property, well, then they're just being ridiculous and can't possibly be right. And so I think, so what's the solution to that? Well, you shrug your shoulders, you go, well, okay. You put your head down and you try to come up with an innovative way to use the rights and laws and the forces that are within the marketplace to create the kind of relationships that will leverage the intellectual property best for those that own it, those that want to own it, those that need to own it. And you can't worry about the folks that upsets, right? Because tomorrow they will be knocking on your door saying, well, why can't you do the same thing you did for them? Can you now do that for us? We have a number of clients that we met because they were across the table from us and said, well, if you can do that, and we were idiots and morons and all those sorts of things, but then when that case was resolved equitably and there was a settlement there or whatever happened, and a licensing agreement was signed, some investment was made, you get an email the next week saying, hey, can you do that for us, what we did for them?
So you still have some time left, and I know it's the very end of the conference, and so the fuel might be running out on people. But does anyone have any questions? Any hands? All right, I see one back there. And while Christina's heading back there, I'll just say that one of the best examples of the awesome benefits of copyright as a property right is that it got it out of the hands of Lucas, who was able to then sell it to a company like Disney, who cares about actually making money and thereby actually taking this product and making it conform to the expectations of the Star Wars fans, as opposed to thinking of it as this great work of art, where Han doesn't shoot first. All right, so question.
First, thanks for the opportunity to be able to be here and to be a part of all of the different panels. It's really been an experience. Thank you all. I was going to say, from an independent creator's perspective, there's never been more of an opportunity to be, whether an independent songwriter or a filmmaker or even an inventor, and then be able to have the ability to outsource or to have your product be viewed by the largest number of people ever all at the same time. But there still seems to be a lot of separation between the inventor, the creator, and then the actual monetization of it. And so there still seems to be a lot of gatekeepers in between and a lot of barriers between being an independent creator or inventor or filmmaker or publisher, or writer, and then actually having that monetization. So where does it kind of come into play as well for having creators to start protecting their works if there may or may not be a real financial future for them? Does that make sense?
I mean, I'm happy to address that a little bit. I don't have a good solution for what happened to Mark Beeson as he described it yesterday, right? Where he writes this #1 hit, and because of factors that are completely outside of his control, and even though he understands them incredibly well, there's nothing he can do about them. There's there's a legal context in which he sits. There's agreements that have been made ages ago that he has to abide by. So I don't know what the solution is there. I can tell you that when we deal largely with patents, we deal almost not at all with copyright, some with trademark, a lot of trade secrets. But I can tell you for inventors, a lot of that is education. Like I was talking about before, a lot of inventors absolutely get taken for a ride when they go to monetize their patents. Right? They don't know the value of them. They don't understand what they actually own. And as a result, they do get taken for a ride, and oftentimes they get taken advantage of. There's been just some programs recently that I would argue are designed and intended to take advantage of inventors who have no other way that they can think of to monetize their assets. And so I think creating a system in which an inventor, as part of the patenting process, I know the Patent Office is trying to do this, particularly for pro se inventors, but as part of the patenting process, you understand what it is you have. You understand the right that you have, and you understand the potential value of it, and you find someone who can help you understand how that value has potentially grown over time since you invented the concept and you filed for your patent and you received your letter's patent. How that value may have potentially grown is critical for inventors, but unfortunately there's not a great infrastructure for that. Does that answer your question? I know it's not a great answer, but it's not the answer you were looking for in terms of a push-button solution, but I do think that inventors taking the time to educate themselves, and we have had relationships with a number of guys that have done that and been successful because of it.
I'll just add one thing to that, which is very short, and it has to do with the contracting environment in which, in talking to Mark Beeson, he's operating. And that's a contracting environment which, as I understand it in the music business, requires compulsory licensing of songs. And anytime you're in a situation where there's compulsory licensing, what you've essentially said to the seller is that you don't get to dictate the price. You must grant a license, and if a license won't be granted, then a court will decide what that right rate is. The outcome of that is that a songwriter writes a hit song and makes $200 a year. It's that kind of arrangement whose roots are the notion of the compulsory license is deadly for innovation and will squeeze young creative people out of the songwriting business and into some other business that they prefer not to be in, where their talents may not be as well used. It's not just about songwriting. I think in general, the notion, this has apparently become very popular in the DOJ these days, the notion that there should be compulsory licenses for all kinds of things, not just creative works, but also, for example, standard essential patents, will lead to the same place, I think, that compulsory licenses have done to songwriters.
Any other questions? So we have just a couple minutes left of the panel, so I don't think there's any necessity to be dogmatist about the exact time frame. So, Mark, why don't you come on up and we'll just offer a few concluding remarks. I want to also thank this great panel. It's always tough to be the last panel of a day-and-a-half conference, and you guys really did a great job in bringing it home. So a hand for the panel. I will stand for a moment and just. So, go ahead, Mark.
Oh, well, I'd like to thank our audience for sticking with us for a day and a half. I hope you enjoyed the I hope you enjoyed the conference as much as we did, and we're very pleased with it. And that's thanks to our speakers who've taken time out of their schedule and who've many of whom are going to be writing articles for us. And I thank them. And I thank Christina again,
Yes.
and thank Matt. And we're very appreciative. We think that this conference, we've really seen some successful explorations of the themes we set for ourselves, and we look forward to the law review issue that will further them, get them into the academic discussion. And for those of you who don't read academic papers, well, we'll be turning them into blog posts eventually and policy briefs and getting them into the policy discussion. So thanks to everyone for coming. Adam?
Yes. So, and I just wanted to just pick up on what Mark just said. That we not only will be publishing some of the remarks in the conference issue being published by the Law Review. So, thank you again to the Law Review staff for all of their great work for the past day and a half, and to their future work with some of the panelists as authors. But we will be posting the videos of the panel. So, if you really want to listen to Professor Sean O'Connor's great riffs again, that will be posted on YouTube, and we will be sending out notices of this through our email list. So to stay abreast of the blog posts and in the videos and the other things that we'll be making available, please make sure to sign up on CPIP's email list at its website at cpip.gmu.edu. So thank you very much.
And as our dean likes to say, onward
Word
and upward. And
so.
let's thank our last panel. Thank you.